thank you so much, everyone, for staying with us. So let's get into it. So much to talk about, and some sort of breaking news that are coming in based on the provisions of the Independent National Electoral Commission (INEC) and its timelines and schedule of 2023 general elections. The umpire is expected to publish the names and particulars of candidates vying for the different position after all primaries and all processes have been done. The commission today did that, and conspicuously, the names of former Minister of Niger Delta Affairs, Godswill Akpabio, the name of Governor of Ebonyi State, Dave Umahi, and that of Senate President Ahmed Lawan were missing on the list. Well, those who are expecting that those names might be on the list because of the controversies that have trailed the processes, the elections and the primary leading up to this moment, were perhaps shocked that this is not happening. Well, there are reasons for that, which we'll be hearing tonight from INEC. There have been controversies over the names of these persons who were seeking to contest other positions. Let's get a sense of what this means. The Supreme Court judgment one, the issue of the possibility of extension of the CVR exercise. If you are yet to collect your PVC or you're yet to register, what are the hopes and that you have to be able to get to do that? And of course, these names that are released, what are the implications? I'm being joined by the National Commissioner of INEC in charge of voter education and publicity, Mr. Festus Okoye, who is here with us in our Abuja studio. Thank you so much, Mr. Okoye. On such a short notice, as soon as I got that information, I reached out to you and you were magnanimous enough to be able to come into the studio. Many thanks for that. Let's get it clearly. Speaking to some of my colleagues across the state, when we're monitoring, as soon as we got information that you have pasted the names and particulars of candidates who were successful in the primaries. But obviously, there are contentions. One concerning the Senate President and Mr. Mashina. Also, that's in Yobe State. The name of Governor of Ebonyi State, Dave Umahi, and the name of the former Minister of Niger Delta. Those names were missing. Are there explanations to this?
Well, the Section 29, subsection 3 of the Electoral Act 2022 obligates the Commission to publish the names of validly nominated candidates within a period of 7 days after the receipt of their nominations. So if a candidate has been validly nominated and if a candidate has passed through valid party primaries and the name of the candidate has been submitted by the leadership of the political party concerned, then the Commission is under a constitutional and legal obligation to publish such a name, to publish the particulars of such an individual or candidate. But if a political party submits to the Independent National Electoral Commission the name of a candidate that did not emerge from party primaries or did not emerge from valid party primaries, the Commission is not obligated to publish the name of such a candidate.
Section 84, subsection 13 of the Electoral Act gives INEC the power to carry out, to reject any names that is not relevant or that is not consistent with what you monitored. And there were contentions about some of these names. And in fact, the fact that some of these names are even, the positions are even blank. Some of the parties have submitted names of people who did not participate in the exercise or who did not win the primaries. Is there any explanation why INEC left this blank?
The Commission has not published the final list of validly nominated candidates. The final list of validly nominated candidates will be published by the Independent National Electoral Commission on the 20th day of September 2022. And that is for presidential candidates and National Assembly candidates. What the Commission has published as of today complies with Section 29, subsection 3 of the Electoral Act, which says that the moment political parties comply with the provisions of Section 29, subsection 1 of the Electoral Act in terms of the submission of its validly nominated candidates, that the Commission shall publish the personal particulars of such candidates in the constituencies where the candidates intend to contest election. In other words, for instance, for a senatorial candidate, if the senatorial district covers 3 local governments or 4 local governments, we will publish the personal particulars of such a candidate in the 3 or 4 or 5 local governments. So that is exactly what we have done. And we published the personal particulars of candidates that emerged from valid party primaries. And that is what the law says we should do. So if the name of any candidate was not published, or if the personal particulars of any candidate was not published today, the implication is that such a candidate did not emerge from valid party primaries.
So there is still a window for political parties to make amendment before you've published the final one.
Well, if a political party did not conduct party primaries, or a political party did not conduct valid party primaries, or a political party has submitted to the Independent National Electoral Commission the name of a candidate that did not emerge from valid party primaries, there is absolutely nothing the commission can do. The only individual or the only person who has the local standard to intervene in such a matter is a candidate that participated in such party primaries. In other words, if 2 or 3 candidates participated in a party primary election, and a candidate believes that he or she won the party primary election and the name of a different person was submitted, that particular candidate can utilize the provisions of Section 29 of the Electoral Act, or Section 84 of the Electoral Act, or even Section 285 of the Constitution of the Federal Republic of Nigeria to seek redress. In that instance, and in that respect, and in that regard, the name of the candidate can now come in by a court order. But other than that, if you didn't submit the list, the name of a candidate that emerged from valid party primaries, the commission cannot bring in such a name thereafter. This is because what we did was that we gave the chairman of each political party an access code to our candidates nomination portal. It is that particular access code that the political parties used in uploading the list and personal particulars of their validly nominated candidates. And the portal shut down on the 17th day of June 2022. So we cannot reopen that particular portal. That portal will only reopen if a court of law makes an order that the name of a particular candidate shall be accepted by the Independent National Electoral Commission. Other than that, no person can come in anymore.
But on your schedule of activities, there is a provision for substitution of names.
You can only substitute the name of a validly nominated candidate. If a candidate was not validly nominated, then you cannot substitute such a candidate.
In the case of presidential candidates or vice presidential candidate,
yes,
that window is open because there is no a primary or election process provided by law to get a vice presidential candidate into the race. So, I mean, it's usually the prerogative of the candidate to pick or to nominate a vice presidential candidate. So the prerogative is also on the political party to want to substitute whoever they think they wanted to substitute. So that window is still open, isn't it?
Well, as far as the law is concerned, and as far as the commission is concerned, the commission makes it mandatory that the moment a presidential candidate emerges, such a presidential candidate must nominate an associate who shall run with him or her as a vice presidential candidate. And so both of them are CMS twins, and they move together and they fall together. Now, in the forms submitted by the various political parties, they submitted forms relating to their presidential candidates, and they also submitted forms relating to their vice presidential candidates. And that is in compliance with the provisions of the Constitution and also in compliance with the provisions of the law. Now, there is a provision in the Electoral Act for withdrawal of candidates validly nominated. And the law provides that a political party cannot substitute a candidate that has been validly nominated except in 2 instances. If the nominated candidate dies, or if the nominated candidate withdraws from the race. And in terms of withdrawal, the nominated candidate shall, in his own writing, write a letter to the political party that nominated him, indicating that he has withdrawn from the race. And that must also be accompanied by an affidavit, duly sworn to by the said candidate. Then the political party that nominated the candidate will now forward same to the Independent National Electoral Commission, saying that our presidential candidate has withdrawn or our vice presidential candidate has withdrawn, and these are the documents of withdrawal, and this is the person we are using to replace. But as of today, the political parties nominated their presidential candidates and nominated their vice presidential candidates. So the issue of withdrawal is at the discretion, an absolute discretion of the duly nominated candidate and no one else.
So INEC is unaware of placeholders, because that's is now there's a birth of that new terminology into our political lexicon. There is what's now called a placeholder holding, because we have not made a decision just yet about a candidate for this position, but just hold, because that's the question again people are asking, that how come, or is there any punishment for political parties who submit to INEC names of people who did not participate at all in the primary, leaving out those who won the primary? Is INEC frowning at this kind of attitude?
Well, let me say this. In the forms submitted by the various political parties relating to their presidential candidates and their vice presidential candidates, what we have in those forms are the names of presidential candidates and the names of vice presidential candidates, and the particulars of those candidates and their sworn affidavit. None of the political parties indicated the fact that they were submitting a document in lieu, or they were submitting the name of a candidate in lieu. All the political parties that submitted the list and particulars of their candidates said they were submitting the list of their presidential candidates and vice presidential candidates. So the issue of submitting a name in lieu or submitting a name as a space holder does not even arise. But as I pointed out, the only way a candidate can go out from the list is if they're in case of death or in case of personal withdrawal by the person who has been duly and validly nominated and through no other means.
Senator Ahmed Lawan's name is not on the list. Mr. Mashina's name in Yobe Senatorial District was not on the list. So, I mean, we understand that APC submitted the name of Senator Ahmed Lawan, but INEC did not publish any name for that position in that senatorial district. Is there any reason why you omitted?
If you look at section 29 subsection 1 of the Electoral Act 2022, and incidentally, I have it here. What section 29 says is that it says that every political party, the onus is on the political party. It says every political party shall, not later than 180 days before the date appointed for a general election under this act, submit to the commission in the prescribed forms the list of the candidates the party proposes to sponsor at the election who must have emerged from valid primaries conducted by the political party. The commission does not submit the list of political candidates. It is the political parties themselves that have been given the locus to submit this particular list. And in this case, there is no personal interface between the commission and the political parties. We opened the portal, what we call a candidates nomination portal, and we gave an access code to the national chairman of each of the political parties that conducted primaries, with which they uploaded the list and personal particulars of their nominated candidates. So if a political party has uploaded the list and personal particulars of a candidate that did not emerge from valid party primaries, the Independent National Electoral Commission is not under a constitutional or legal obligation to publish the particulars of such a candidate.
So a reason, that's probably the reason. Now, the question is that, let me ask quick question, two quick questions before I now go to the substantive question that I'd like to ask. The first thing is that INEC only recognizes primary that you observed, isn't it?
The commission recognizes valid party primaries, political party primaries that were conducted in accordance with the Constitution, in accordance with the Electoral Act, and also in accordance with the guidelines and regulations of the various political parties.
Now, do you compare the primary that you monitor and the list of the candidates submitted by the political parties?
Well, those ones are within the internal realm of the Independent National Electoral Commission.
But is that a standard procedure for INEC?
We have our own standard procedure.
For verification?
We have our
Should the political parties not align with the standards in which you have set for monitoring the primaries? Because the reason why I'm asking the question is that a lot of the times, and which of course in these cases that we have seen, INEC will monitor a certain primary, and there is a parallel primary going on elsewhere, and there are confusion. In the case of Godswill Akpabio, we understand that there was a call for a reconduction of the primary, and it was conducted somewhere else, and perhaps INEC was in another place and all of that. So there are this confusion, and perhaps the reason why Godswill Akpabio's name was not present on the list. But the question again is that there are names that are being present on the list submitted by political parties against what INEC monitored on the ground.
Section 82 of the Electoral Act makes it mandatory that every registered political party that wants to conduct primaries must give to the Independent National Electoral Commission 21 days notice of its intention to do so. And such a political party shall tell the commission the venue where the party primaries will take place and the date when the party primaries will take place. Now, if for any reason the political party is unable to secure a particular venue, or for any reason it wants to change date, the political party shall give to the Independent National Electoral Commission 7 days notice of its intention to change. So if you have given the Independent National Electoral Commission a date and a venue, and we go to monitor such party primaries, and then we issue a report, or we write a report relating to such party primaries, and then you go again somewhere else, not to the notice of the Independent National Electoral Commission, to go and conduct something else that you call party primaries. Of course, whatever you have done there cannot be said to be a valid party primaries within the contemplation of Section 82 and Section 84 of the Electoral Act 2022.
So how do you resolve the names that you left open and blank? There are primaries conducted, party did not submit the right name, and you did not publish any name. How do you resolve it?
Well, what the law has said is that any person who has any complaint relating to the conduct of party primaries, relating to the names of candidates that have been submitted, and also relating to possible violation of the Electoral Act or the rules and regulations or guidelines of a political party, can seek redress before a federal high court.
All right, let's go, because we spent a good time on that matter. The implication, because any decision of the court on any law, extant law guiding our election, and even that the ones that affect your guidelines, because that also, the Constitution has empowered INEC to set up a guideline for every election that it conducts. So if anything affects those laws and those rules, then there are implications. For the ruling and the position of the Supreme Court today, what implication does it have on INEC?
The political parties have already done their congresses, have done their conventions, and they had already made a decision on who should be voted for and who should not be voted for, and who should be a delegate and who should not be a delegate. I think that some of the political parties were properly guided, and they decided that it was in their best interest to err on the side of caution by not allowing a certain category of political appointees to either be voted for or to be voting delegates. So I think that we have passed the stage of congresses and conventions, and the political parties have complied with the provisions of the law. And if any aspirant, for instance, believes that any provision that his or her political party did not conform, or that if his political party violated any of the provisions of the Electoral Act, that such an individual has the right and the locus to challenge such an action before a court of law.
So there won't be any retroactive effect of this position of the Supreme Court, because, of course, the subsection 12 of Section 84 of the Electoral Act is talking about congresses and voting delegates and all of that eligibility of a voting delegate or aspirant. So that has passed, will move forward. So there is no retroactivity of that.
The law is the law. Section 84 of the Electoral Act came into force the day the president signed into law. So nothing has happened to change that particular situation.
So for sure now, INEC is convinced of a possibility of extend the deadline of CVR, the voter registration exercise.
The chairman has been very clear, and has been very consistent that the Commission is disposed towards extending the date for the continuous voters registration exercise. But we can only do so at the conclusion or determination of the case that is pending before the Federal High Court. We are going to go before the Federal High Court on the 29th day of this month to put the cards on the table. And we are convinced that after we make arguments, that the court will be convinced on why we cannot extend the CVR beyond a certain period. But we are convinced, given the enthusiasm of Nigerians, given the new resolve of Nigerians to register, that an extension is inevitable, and we are definitely, the Commission is disposed towards extending the period for the CVR, but not up to the period that some people are canvassing.
Beyond the adversarial debate in the court, in the precinct of the courts, yes, come to the level of advocacy. Those who are saying, we're not fighting you, we're not even holding you into them and taking you to court over this matter. Yes. We're saying, for the sake of those who need more time, the House of Reps are also seeking INEC's mercy to extend this. Are you also looking in that respect beyond the adversarial contest that is going on in the court?
Definitely. The Commission is convinced that getting more people into the voters' roll will add value to the electoral and democratic process. We want as many people as possible to be in a position to register and show up on election day and vote. And for those who have lost their PVCs, we want a situation where they can replace their PVCs. For those whose PVCs are defaced, we want them to replace them. For those who want to transfer from one state to the other, or from one local government to another local government, or from one registration area to another registration area, we want them to do all these things successfully. But we also want a situation where these things can be done, and then we'll be in a position to clean up the voters register, to do claims and objections, and also to print the permanent voters cards of the registrants and get them to collect these things. It will be a futile exercise to extend the period to an unreasonable time, and then at the end of the day, be unable to print the permanent voters cards of these new registrants and get them to collect these cards. Right. We want them to collect these cards, and we also want them to show up on election day. So we are favorably disposed to an extension of the CVR.
I just have like 40 seconds to break. I'm due for a break, but Edo State PDP candidates' names were omitted. They're not. Is it because of a court? Yes, I think there's a court order relating to the list of and personal particulars of PDP candidates from Edo State, and we have a history of obeying court order. All right. So, lastly, does INEC have the power to reject candidates that did not emerge from the primary? I don't think it is fair for me to answer that question. If you look at Section 285 of the Constitution, you look at Section 29 of the Constitution, and you also look at Section 84 of the Electoral Act, I think you can find the answers there. The Constitution, Section 285 of the Constitution of the Federal Republic of Nigeria, makes it very clear that if a political party complains or is not happy with the decision of the Independent National Electoral Commission relating to the rejection of his candidate, that such a political party can go to court. So the answers you are looking for are embedded in the constitutional framework and also in the Electoral Act. We will continue to act in the best interest of the people of this country, and also in the best interest of our democracy, and also in conformity with the Constitution and the Electoral Act. So you don't have a yes or no answer, whether or not you have the powers to reject anyone who does not emerge from the primary? I'm saying that our powers are embedded in the Constitution. It's in the affirmative. And we have the power. We will continue to exercise the powers donated to us by the Constitution. And those powers that have not been donated to us by the Constitution, we will not exercise them. Mr. Festus Okoye, I must sincerely thank you, because I called you out in the very close timing to this program. Thank you so much for honoring the call. Thank you so much indeed. I appreciate this opportunity.